All right, this is case number 2012528FH, People of the State of Michigan versus Christopher Allen Scott. Mr. Scott is present in court with his attorney, Mr. Prysock. People are represented by Mr. Stay. This is defendant's motion to modify bond. You can go ahead, Mr. Prysock.
Thank you, Your Honor. Your Honor, as the court knows, we appeared in front of Your Honor on the circuit in Oceana County on Monday. Mr. Scott had his bond revoked there. Your Honor set his bond at $10,000 cash. For surety, he posted that bond, and that was for a case in Oceana County involving alleged home invasion and alleged UDAA. We now come to this case in Wago County. Mr. Scott failed to appear on March 2nd. The court at that time revoked his bond and set a $50,000 cash surety bond. We're asking the court to consider a reduction of that bond. He did post that $50,000 cash. We're asking the court to consider a lower bond, commensurate with the bond in Oceana County. We're asking the court to set a $10,000 cash surety bond here and return the balance of the bond to Mr. Scott. The reason being, Judge, that Mr. Scott has and did have to borrow money to pay that bond. He needs money for his living expenses. He is retired and is disabled and cannot work. He also needs the money to, as I said, reimburse people that he has had to borrow money from. And also, he needs money to pay attorney fees, Judge. I know the court had some concern about him receiving a court-appointed attorney, but with the funds that the court agrees to reduce his bond, he's going to retain me on these cases. And he's already paid a partial retainer on the Oceana County case. He intends to retain me on the Wago County case. So we're asking the court to free up a portion of his money, Judge, so he can meet those obligations and commitments that he has. He's been in constant contact with my office. When he bounded out from Oceana County the next day, on Tuesday, he was in my office within an hour. He's been in my office and was there for his pretrial hearing that we had on Wednesday. We set that case for jury trial, called the court's attention to the fact that this is a 06 operating while intoxicated. There are no injuries regarding this case. And I believe we have, again, a very triable case here, Judge. I can tell the court that I have a stack of medical records for Mr. Scott, that probably at least 900 pages. He has some disabilities. He takes medications. And the reason that he's missed court appearances, Judge, is because of his medications have been changed. He has some memory problems. His medications are now adjusted. He's seeing his doctor, and he also is here with Ms. Kathy Dugas. She's a mental health, works in the mental health field, and she is monitoring his behavior, making sure that he appears for court. He's been constant contact with my office. I even took the unusual step, which I usually don't do, gave him my cell phone number. So he's been very responsive, Judge, and I believe that in the future he will be responsive. So we're asking the court to reduce that bond as I'm requesting in my motion from $50,000 to $10,000.
All right, Mr. Stay, any response?
I mean, it's an unusual position to be in, Your Honor, when the defendant has posted the bond. I mean, he's essentially asking for a refund because he has appeared now. You know, a lot of these things mentioned by defense counsel really don't go to the court rule as to why and how bond is set. They're more asking for equity decision from this court. I would leave it in the court's discretion.
All right, so a couple of questions for you, Mr. Prysock. What is the date that the alleged home invasion first and UDA was alleged to occur in Oceana County?
That was on August 30th, Your Honor, 2020.
I don't think that's, I at least have from Mr. Bison, the Oceana County prosecutor.
I'm sorry, Judge. That's this case. I do not have my Oceana County file here with me, Judge.
I have an email from Monday that indicates it was October 2nd, 2020.
That sounds right.
And again, Judge, that's kind of a pattern of behavior that was occurring because of his medication problems. As a matter of fact, there was another operating while intoxicated where he was a 0-0. And Mr. Stay ended up nolly prosecuting that case because, again, his condition, Judge, the officers believed he was highly intoxicated. He was slurring his words. He fell down. And it turns out that it's for a physical condition that he has, Judge. So,
You certainly shouldn't be driving with that, whether it's in that condition, whether it's alcohol or physical. I mean, that doesn't sound like it's safe for him to be on the road like that.
he's not driving anymore. Ms. Dugas provides him with transportation, but at the time he didn't know it, Judge. And these incidents that have occurred all in a short period of time brought this all finally to light.
So next question. You said Mr. Scott is on disability and he does not work. Is that correct?
That's correct. He's retired. He wasn't working as a construction foreman and supervisor for a number of years.
All right. And what is his monthly income?
$2,200 a month, Judge.
Where does that come from?
Social Security disability.
And that would have been disability insurance benefits, Judge, and the amount is based on the amount that you pay in. Since he was a construction supervisor, that's why he receives that much money.
Does he have any assets?
No.
Yes,
Oh,
a truck.
Okay.
You own a home, you're renting or what?
I'm staying at Swan Inn Motel. It's in Comstock Park, Michigan, in room number 28, and that runs, it's $560 a week. It's the cheapest one that I've been able to find.
Well, you've been living in a motel.
Shortly after I got out this last time,
Where did you live before that?
Catherine's house.
So where did you come up with well, number one, in Oceana County, did you do a bondsman or did you put up 10,000 cash in Oceana County?
That was
Okay,
cash.
10,000 cash.
So where'd you come up with $60,000 between the two counties for bonds?
It's been 6 years on lithium, living with Kathy. And over that course of that time, I just was able to save up enough money to be able to go out on my own. When I went out on my own, I bought the truck because of the accident that I had in Nuevo with the SUV. So I was able to have $25,000 to purchase the truck. And the rest has been going fast.
That represents, most of that, Judge, represents his life savings.
It's a long story, Your Honor.
That period of time that he was living with Ms. Dugas, he was able to save money. He doesn't have any retirement funds.
In my last divorce,
He doesn't have any retirement funds or anything, but he was divorced and that pretty much wiped out his pension.
All right. In this case, the court is not going to reduce the bond in this case. There's a couple reasons. Number one, in reviewing the register of actions from this case, It appears that there was a bond violation while the case was still in district court with the defendant consuming alcohol. Then he failed to call in as directed to this court on December 8th. The court had set a bond at $15,000 cash or surety. He must have contacted the court. He must have set aside that forfeiture. Then again, on March 2nd, he failed to call in for the pretrial. The court set a bond at $50,000 cash or surety. So he's demonstrated that he'll consume alcohol in violation of the bond, that he won't, for whatever reason, appear in court as directed, even by phone. He also has new serious felony charges that are allegedly occurred while he was out on bond for this case in Oceana County, home invasion first degree. That carries a 20-year maximum. And based on all those factors, the court doesn't think that a reduction in bond is warranted. So it was a cash or surety bond. If he didn't want to tie up his life savings, he could have gone the bondsman route. I appreciate the fact that Mr. Scott wants to hire an attorney. There's $60,000 out there. Mr. Scott could easily just do an assignment of the cash bond, and fines and costs, and as soon as he's even convicted, it wouldn't be anywhere near $50,000 or $10,000 in the other case. So Mr. Prysock most likely get paid. It may take a little while, but the money will certainly be available. But that's between the two of them. But based on these facts, his failure to appear, continuing to consume alcohol, and new alleged serious felonious activities while out on bond for this case, $50,000 cash or surety bond is appropriate. The motion is denied.
Thank you, Judge.
Thank you.